Okay, today I'm doing joinder of parties and joinder of claims. We'll do joinder of parties first. This is for con law. This is my video number 5. Joinder of parties. There's permissive joinder. Plaintiffs and defendants may be joined to an existing case if the claim arises. These are the important words you want to see. If the claim arises. I wonder how I get a little bit let's see here. There we go. So if the claim arises under the same T&O transaction in occurrence. This is for joinder of parties. Permissive joinder, plaintiffs and defendants may be joined if the existing claims arise under the same T&O and raise at least one common question or fact of law. And remember, SMJ is needed. So if you get a joinder essay or a question on joinder, can the defendant be joined? You need to write an SMJ first, go through your whole SMJ analysis. If you don't have a good approach to that, I do have a video on SMJ for con law. I believe it's con law video number 2. Okay. Then we have joinder of a necessary party. This is important on MBEs too. A party is necessary if courts cannot provide complete relief without the necessary party. Absent party's interest will be harmed. So if the party is absent, their interest will be harmed. If the absent party is subject to multiple inconsistent obligations. Necessary party must be joined if. So this is how you have to figure out if the party is necessary. So you write up your little elements on this. Is the party necessary? You got to write yes or no based on these. And then must the party be joined? Okay, must the necessary party be joined? First of all, find out, are they necessary? Then you're going to write down, must they be joined? They must be joined if court has PJ over him or hers. Obviously, you got to go through your personam jurisdiction analysis. And joining does not destroy diversity. Okay, got to do those two. If unable to join, the court will consider an alternative forum, assess likelihood of prejudice towards the necessary party, may dismiss or proceed with the case without the necessary party. So this is a decision of the court. Okay, and that's for necessary party. Then we have Interpleader. Defending party can use to add a third party defendant in order to seek indemnity or contribution. So usually we're going to implead someone if the defendant wants to add the third party defendant, but they have to be seeking indemnity or contribution based on some kind of cause of action. Okay, supplemental jurisdiction does apply here if claim meets a common nucleus of operative fact. California calls this a cross complaint. So it's an implead. To implead someone in California, it's called a cross complaint. Venue need not to be proper for the third party defendant. So venue does not need to be proper for the impleader. So a defendant is seeking indemnity or contribution. Supplemental jurisdiction does apply, remember, if it's a common nucleus of operative fact of the main cause of action. And California calls it a cross complaint, and venue does not need to be proper. These are just memorization things here. Intervention is different. When a non-party claims an interest in the property, so this is based on property. Intervention, think of property. Or transaction that is the subject of the pending lawsuit, and disposition in his absence will impair his rights. California needs to be direct and intermediate. Okay, this is intervention. Intervene into a case, and you'll see lots of MBs on those. Interpleader now is different. Is an action where one holding party, the stakeholder, forces all potential claimants to the land, claimants to the property, into a single lawsuit to avoid multiple and inconsistent litigation. There's 2 types. There's statutory and Rule 22 interpleader. Statutory requires only one claimant must be diverse from one other claimant, and the amount in controversy must be $500 or more. For Rule 22, requires a stakeholder, which is the person up here holding the property, must be diverse from every claimant. Amount in controversy must exceed $75,000. So there's statutory law on that, and there's Rule 22 federal law. Now we're going to go to that was it for joinder of parties. So joinder of parties, they can be a necessary party, You can implead a party, intervene with the party, interplead with the party, and now we're going to go to joinder of claims. These are counterclaims or counterclaims. There's two types. Compulsory counterclaim, we'll talk about that first. Arise from the same T&O, compulsory. They arise from the same T&O as the plaintiff's claim and must be raised in the pending case or the claim is waived. Supplemental jurisdiction does apply. An independent basis for subject matter jurisdiction is not required since supplemental jurisdiction will extend to a compulsory counterclaim. So SMJ is not required for that separate little counterclaim because it will extend to it. So SMJ is not required here. Okay. Joinder of claims continued. There's a permissive, so we have the compulsory, which is the same T&O. SMJ is not needed. Then we have the claims, joinder of claims for permissive counterclaim. A permissive counterclaim does not arise from the same T&O, does not. May be raised in the pending case or in a separate case. No supplemental jurisdiction, there's none here. We have supplemental for joinder of claims. Why? Let's go back there real quick. Why do we have supplemental for joinder of a compulsory counterclaim? Because supplemental jurisdiction has the same T&O. That's exactly why. Joinder of claims does not have the same T&O, does not arise out of the same T&O, so obviously there's no supplemental jurisdiction. A permissive counterclaim must have an independent source of subject matter jurisdiction. So here we need subject matter. Compulsory, no subject matter is needed. Why? Because we have the same T&O, so we can use supplemental to jump right in. Joinder of claims permissive, no, there's no same T&O, so there's no supplemental jurisdiction, so we have to write a separate thing on SMJ for a permissive counterclaim. California uses the term cross-complaint. For all third-party actions, such as counterclaims, cross-claims, and impleader, they're going to use cross-complaints. A cross-claim is an offensive claim against a co-party and must arise from the same T&O for California. It's never compulsory. Why? Let's go see. Here's my compulsory. California is never compulsory because it must, right? Because it must arise from the same T&O. Never compulsory, cross-complaint in California. Supplemental jurisdiction is allowed. An independent basis for subject matter is not required since supplemental jurisdiction will extend to a cross-claim. Compulsory, you don't need subject matter jurisdiction. Supplemental jurisdiction does apply as long as there's the same T&O. That's for California. A little bit, it's kind of the same as federal. Class action. I've seen these on MBEs. Class action, a case where a named representative sues on behalf of a group. Federal court class actions requirements, numerosity, commonality, typically adequacy and type of class. Citizen issues, diversity action, only the citizenship of the named representative. You see these on MBEs. They'll give you a different person that is going to break diversity. It doesn't matter as long as the citizenship of the named representative is diverse from the defendants. $75,000 amount controversy can be satisfied by any named class rep. That's important. Class Action Fairness Act applies where there isn't complete diversity, allows the federal court to hear a class action if the following are met. Diversity, any class members diverse from any defendant. Aggregation, the class claim aggregate to exceed 5 million and 100 members. There must be at least 100 members. California class actions allowable if there is an ascertainable class and a well-defined community of interest among the class members. The type of class, only one type of class. Notice, individual notice is not required in California. Okay, so we went over joinder of parties and claims, joinder of parties, permissive joinder, how to add a necessary party, and how do you know if it's necessary? You go through these. And must they be joined? We don't know based on the facts. If it's unable to join, what can the court do? Then went to impleader, intervention, interpleader. Now I went to joinder of claims. Remember, compulsory, same T&O. Supplemental jurisdiction, no SMG is required. Joinder of claims, second type is permissive counterclaim. Do not arise out of the same T&O. Thus, we do have to do an SMJ here. There's no supplemental jurisdiction. California uses the term cross-complaint. There's class action. There's a difference between the federal class actions and what is needed here. Remember, only the citizenship of the named representative, 75,000 amount in countries, can be satisfied by any named class representative. And then California has its own rules for class actions. Okay, so that's it for this video. Nice, quick, and to the point. You just kind of have to memorize the elements here and do a lot of MVs on them and write up some essays, and you should be able to see how all of this works together. And I'll see you guys in my next video.